Nearly 200 families served eviction notices by their own councils, Labour councils, the same party that promised to ban these evictions, the same party that swept to power promising reform. This is happening right now, in England. Since July 2024, 5 Labour-run councils have issued 191 no-fault eviction notices through their housing companies. Lambeth Council alone issued 63 notices. Reading issued 48 more, Blackpool added 73. Between July 2024 and June 2025, 11,400 households in England were forcibly removed by bailiffs. 11,400 families gone. The Renters' Rights Bill is coming, promises made, reforms pending, but something isn't adding up. Section 21 evictions, no-fault evictions, the landlord's nuclear option, 2 months' notice, no reason required, you're out. Labour donor Lord Ali evicted a family of 5 before raising their rent from £4,800 to £5,700 per month, a 19% increase. Days after the eviction notice, the property was listed at £6,000, a 25% jump. The family had lived in the 5-bedroom North London townhouse for 4 years. They offered to pay the full £6,000, refused. They asked to stay an extra month so their children could finish exams, refused. Lord Ali has donated over £500,000 to Labour since 2020. He's worth an estimated £200 million. Documents show Lambeth Council delayed eviction plans because they were deemed too controversial during the pre-election period. Too controversial before votes were counted. Perfectly acceptable after. The news came 1 month after Rushanara Ali resigned as the government's homelessness minister. She had evicted 4 tenants from a property she owns, then re-let it weeks later for £700 more per month. The homelessness minister. Causing homelessness. Local authorities cannot normally issue Section 21 notices. They're councils, not private landlords, but some found a workaround. Arm's-length companies set up to manage council housing stock can offer assured short-hold tenancies, the same tenancy type used by private landlords. Same legal structure, same eviction powers. Lambeth set up Homes for Lambeth in 2017. The council is now disbanding it. But not before 5 households received possession orders and 2 were removed by bailiffs. Reading Council announced plans to close Homes for Reading 2 weeks after the general election. Since then, 48 households evicted, 20 already gone. Some vacated homes are being used as temporary accommodation for homeless people, despite being designated for key workers. Some families evicted by Homes for Reading have been forced into temporary accommodation elsewhere. The circle closes. Evict tenants to house the homeless. Create new homeless in the process. A Reading Council spokesperson said the decision was taken as a last resort after the company's viability was affected by changes to lending rules and economic factors. The spokesperson said the properties have been bought by the council's housing revenue account. The legislation requires vacant possession at the point of acquisition. Vacant possession. A bureaucratic term. It means empty, it means no people inside. Charlene, 38 years old and from London, a mother to a 4-year-old son. She received a no-fault eviction notice in May. Now she and her son share a bed in a bedsit without a working washing machine. She says, "Everything seems very hopeless at the moment. This place is vile. If my apartment, which I loved, is also being used as temporary accommodation, I could have stayed there and been near my son's school." Her old flat, the one she loved. Now, temporary accommodation for someone else. Jules, 27 years old, said she and fellow tenants were traumatized by the thought they too may end up in temporary accommodation. Some were suicidal over housing. Blackpool issued 73 no-fault notices since Labour took power. 15 households received possession orders. 3 evicted by bailiffs. The council often uses notices to address drug use and antisocial behaviour. But there's a problem. If tenants breach agreements, landlords are supposed to issue a different type of notice that allows court challenges. Section 21, bypasses that right. No defence, no day in court. Blackpool Housing Company said no-fault evictions were a last resort. In most cases, notices don't lead to evictions because the process, with support, sustains tenancies. Nottingham City Council established Nottingham City Homes in 2004. In 2017, it created a subsidiary offering assured short-hold tenancies. In 2022, the council announced plans to disband both organisations after about £50 million of housing funds were wrongfully spent. £50 million gone. About 100 families with assured short-hold tenancies lost their homes. The council began eviction proceedings before the election and continued pursuing tenants after Labour entered government. Since then, 2 more no-fault notices issued, 2 possession orders sought, 1 property seized by bailiffs. A council spokesperson said enforcement action was necessary only after an extended period was provided to allow the tenant further time to move. The council said it does not plan to carry out more no-fault evictions. Enfield Council owns My Housing Gateway. 5 households were issued with no-fault eviction notices since last July. All 5 households were removed by bailiffs. The Renters' Rights Bill, Labour's landmark reform. It will return to the House of Commons on 22nd October 2025 for final approval. After that, royal assent, then law. The bill bans Section 21 evictions. It ends assured short-hold tenancies, making all tenancies periodic. No fixed terms, no end dates. Tenants can leave with 2 months' notice. Landlords need valid reasons to evict. When tenants move in, they're protected from eviction for 12 months. After that, if landlords want to sell or move in themselves, they need 4 months' notice. Landlords must join a new, private rented sector landlord ombudsman service. Tenants can make complaints. The Ombudsman provides binding decisions requiring compensation or property improvements. Rent increases limited to once per year. Increases must align with market rates. Communicated via Section 13, notice with 2 months' warning. Tenants can challenge unreasonable increases. The bill extends Awab's law to private rentals, requiring landlords to address hazards like damp and mould within specific timeframes. The Decent Homes Standard will set minimum requirements for all rental properties. Discriminatory practices like no DSS adverts banned. Landlords can still complete referencing and reject tenants due to affordability. But they cannot reject tenants for receiving benefits or having children. Bidding wars banned. Landlords must publish an asking rent. They're banned from encouraging bids above the advertised price. Fines for non-compliance set at up to £7,000 for initial offences. For serious offending, fines could reach £40,000 or criminal prosecution. Rent repayment orders strengthened. The maximum amount a landlord can be ordered to repay will double from 12 to 24 months. Reform, protection, enforcement. But when? Royal assent imminent. But implementation is different from legislation. The government will need to publish regulations and set a commencement date. The government says it will give everyone sufficient time to prepare. The commencement date is likely between spring and autumn 2026. 6 to 12 months away. Meanwhile, evictions continue. Ollie Sherlock of Goodlord said the actual commencement date will likely be in early 2026. While the government is keen to implement abolition of Section 21 as soon as possible, other parts won't take effect immediately. The timeline matters. Every month of delay is another month of Section 21 notices. Research by Spare Room claims 2/3 of UK landlords plan to leave the rental sector or reduce portfolios this year. 88% express no confidence in the rental market in 2025. Simply Business research found 66% of landlords think it will be harder to regain possession without Section 21. 71% said they'd never used Section 21, but they want it there. The threat matters more than the action. Property Mark warns more landlords could exit due to extra regulations. Tenants can end contracts with 2 months' notice. This increases landlords' costs and uncertainty. This could lead to fewer properties for tenants to rent. Good Lord warns the ban on bidding wars could cause rapid rent price increases. With landlords forced to accept advertised rents, many will raise prices from the start. Removing Section 21 may lead to more rental disputes going to court. Thousands more tenants could receive county court judgments for rent arrears, damaging credit scores. Protection that backfires. The National Residential Landlords Association has labelled some changes a dog's dinner. Chief Executive Ben Beadle said the government expects responsible landlords to shoulder even greater risks without consultation. Before Labour came to power, the government promised to immediately abolish no-fault eviction. Immediately. It has yet to name an implementation date, 15 months after the election. A ministry spokesperson said Section 21 no-fault evictions are unacceptable. That's why we're banning them through our landmark Renters' Rights Bill, which is set to become law very soon. Unacceptable, but still happening. Very soon, but not yet. Meanwhile, Lambeth Council said it faced incredibly difficult choices, but decided to use properties to house those already homeless. Noble goal, brutal method. A Reading spokesperson said closing homes for Reading was a last resort after the company's viability was affected by changes to lending rules. Last resort. For the council, first disaster for tenants. This isn't about housing policy. Not really. This is about timing, about who pays the price for transition. The bill will pass. Section 21 will die. Eventually. But between promise and implementation, families are being moved, lives disrupted, children uprooted. A father evicted from Lord Ali's property said, "The hypocrisy just feels like too much. I voted Labour and I'm just incredibly disappointed." Disappointed, evicted, betrayed. 71% of landlords never used Section 21, but they want it there, just in case. Tenants want security, landlords want flexibility. The bill tries to balance both. The question isn't whether reform is needed, it is. The question is, what happens to the people caught in between? What happens to Charlene and her 4-year-old son? What happens to the 191 households served notices by their own councils? What happens to the 11,400 families removed by bailiffs while we waited for reform? Nearly 200 families, 5 Labour councils, 1 legal loophole. The Renters' Rights Bill is coming. Royal assent any day now. Implementation in 6 to 12 months. But the evictions are happening today. The promises were immediate. The action is eventual. And somewhere in that gap, Charlene shares a bed with her 4-year-old son in a bedsit without a working washing machine. Wondering why her old flat, the one she loved, couldn't just be hers. This is what's really going on. Behind the reform, behind the rhetoric, behind the rights, people waiting. So until the Renters' Rights Bill actually becomes law, tenants remain vulnerable to no-fault evictions under Section 21. It's a concerning situation for millions of renters across the UK. What are your thoughts on this? Are you a tenant worried about Section 21, or a landlord with concerns about the changes? How do you think this will impact the market and, more importantly, people's lives? Is there a better solution? Let us know in the comments below. We'd love to hear your perspective and about your own personal experiences. If you found this breakdown helpful, don't forget to hit that like button and subscribe to Property Brief UK for more essential updates on the UK property market. We cover everything from legislation changes and market trends to practical advice for tenants, landlords, and investors. Ring the notification bell so you never miss an update that could affect your property decisions. Thanks for watching, and we'll see you in the next one.